All right, good evening and welcome. We're going to start as on time as we can. Tonight's webinar is learning how an enduring power of attorney works. So what it is, what powers there are, when it can operate, what obligations someone has when they're appointed as a power of attorney, why it's important, all of these things. So we're going to jump straight into it. If you have questions as we go, please put them in the chat box. I will come to those at the end. There is a Q&A box there as well. If you want to use that, I will check it at the end too. For those watching the replay, if the webinar is embedded in a special page, there will still be a place to submit a question that will be emailed to me and I'll get back to you in 24 hours. So here we go. Enduring powers of attorney. But first, I'll introduce myself a little bit better. So my name is Jackie Broman. I am the owner of TBA Law. There's a much more professional photo of me on the screen there. I'm obviously coming to you tonight from home. So you're seeing me in a much more natural environment. And excuse if my dogs run around like crazy this evening, but hopefully the audio won't be too impacted because you're coming through my headphones anyway. Now, I am an accredited specialist in wills and estates. So that's what that special swirly logo is. So just to explain, I'm a solicitor, so I have all those qualifications. I then went and did a master's degree specifically in wills and estates. And then after that, the Law Institute of Victoria runs a 12-month program every 2 years to get accredited. So I did a 12-month program with a big exam, 3-part exam thing at the end, and got through that. And there's lots of different specialties people can go for. But just to give you some context, there's about 22,000 lawyers in Victoria. Only about 80 of us actually have the wills and estates accreditation. So despite all that, I am also a human with other interests. So there's a photo there of 2 of my other passions. I've already mentioned my dogs tonight. That's one of the rascals there. I go fishing a lot, particularly in the ocean. I love getting away, getting out into nature. It also gets me off the phone and the computer. That particular dog needs to be tied up all the time because he loves the white water and would be over the edge in a second if he could. So enough about me. Let's jump into just an overview of what estate planning is in 2020. So it's not just about doing a will, and you already know that because you're here tonight learning about powers of attorney. You know, 50 years ago, and even as recently as maybe 30 years ago, estate planning really was just a will. Life was simpler. There really wasn't superannuation. People's dreams were maybe a little bit smaller. We aspired to a house. Now quite a few people have multiple investments, or they have a family trust, a business. There's superannuation. There's self-managed superannuation. People are living for longer. We have, and living longer comes with medical issues and decline in health, and that is really where the powers of attorney fit in. Tax consequences have all sorts of things have changed over the last 30 years. And, you know, aged care has just become this big mammoth industry as well. So these are all the aspects that we're now thinking of when we're doing estate planning. So the complexity of our lives has changed. And so when people say, I just need a simple will, and then they explain to me, you know, they're on their 3rd marriage and what they own and all sorts of things, I'm like, yeah, just simple, yeah. All right. So into the crux of it. Powers of attorney. So specifically, we're learning about the enduring power of attorney tonight. So there are different sorts of powers of attorney. The enduring power of attorney is enduring because it endures past you losing your mental capacity, which is the main purpose of it. So quite often I encourage people not to even begin the power of attorney until you lose capacity. So it sits dormant and is triggered once you lose capacity, because there's very little reason really, if you're sound of mind, for someone to be running around doing things for you. So the enduring quality is the really important part of it. You can have a general power of attorney. And the main purpose of a general power of attorney would really be to just do a specific thing. A general power of attorney finishes as soon as you lose capacity, or finishes on whatever condition you put in the general power of attorney. So the best example is if you are doing some kind of big deal in Australia, like you've got a property for sale and you've also got a 6-week holiday planned overseas, not that you can do that in 2020, but you could give a general power of attorney to someone for that specific purpose for a specific period of time, and that is a general power of attorney. Another sort of power of attorney is a supportive power of attorney. Now this is a sort of hybrid, strange document. It is like a general power of attorney, but it's put in place when someone is again declining in age or health, but they're still mentally sound. They just need someone to help them out with some things. So that's a supportive power of attorney. To be honest, they're very rarely used because other documents can really suffice. And the other type of power of attorney, which the name has changed slightly, is the medical power of attorney. So in 2018, the name of that changed to an appointment of a medical treatment decision maker. It has the same effect, and it is enduring as well, because again, you appoint someone to make medical decisions for you if you can no longer make medical decisions for yourself. So it endures past you losing your mental capacity. So those are the types of powers of attorney. Now, when do they start? They start when you specify them to start. Now, it's just specifically talking about the enduring power of attorney. There are 3 different times when you could get a power of attorney to start. If you don't specify, it starts immediately. It starts from the date that you sign the document and it's valid. And quite a lot of people actually, when they make them, default to it starting immediately. In some situations, I don't think that this is a huge issue, particularly where you're appointing your spouse first, because there's very little chance that it will be abused by a spouse. Although having said that, you know, financial abuse is a thing. So I tend to advise people with your enduring power of attorney to say, well, no, it only begins once I've lost physical or mental capacity, in which case it's not beginning until a medical certificate triggers it. So it sits there dormant. The other scenario is that you could put another condition on it. So that's the third option. It could begin on some particular event, and you can select whatever condition you like for that. It could commence when you're no longer residing in Australia for your Australian scenario, or whatever that may be. So you actually specify when an enduring power of attorney starts. If you put a condition in it that it starts if you lose capacity and then you regain capacity, then it can go back dormant again. Similarly, if you say that it operates while I'm not in the country, and then you come back and you're in the country, it should stop operating. The problem is that if the document is presented by the person that you appoint, the attorney, how does the institution that they're dealing with know that the condition is no longer operating? So that's something that we'll talk about in a little bit in terms of the abuse of some powers or the potential of abuse of powers. So how do you utilize a power of attorney practically and legally? Now, if you follow my advice and you create your enduring power of attorney and it doesn't begin until you lose capacity, then you have this dormant power of attorney sitting around, and hopefully you've got a certified copy. Because if there was an accident and you had a head injury or you had a sudden stroke, your attorney has the certified copy ready to use, and they'd get a medical certificate, and they'd be able to then present that to the bank and say, yes, I've got power of attorney. That would then be held on file at the bank. You could deal with other institutions, people like council, like utilities, phone companies. So the enduring power of attorney really covers financial decisions, legal decisions, if the power is given, and also some lifestyle decisions. So if you make a medical power of attorney, it only covers medical decisions. It doesn't cover lifestyle decisions. The enduring power of attorney does cover lifestyle decisions. And so the lifestyle decisions that an attorney can make include where you're going to live, where you're going to receive treatment, who is allowed to come and visit you, who is excluded. So some of those decisions as well can overlap with a medical power of attorney, or feel like more of a medical decision, but in fact, it is a lifestyle decision. So because we've got all these elements of powers that we can give in an enduring power of attorney, you can actually break them up between different people. So you don't just have to go, my kids are all appointed. I want all three of them to have joint power, and they've got all the powers. So they have to act jointly and they can make all the financial, legal, and personal decisions. No restrictions. So you could do that. Or you could go, okay, so I have 3 kids. One of them I really trust to make my lifestyle decision. So I'm going to actually specify that that person has the power over the lifestyle stuff. The others aren't. And 2 of the 3 kids, I'm happy that they're really financially savvy. I'm going to have them act jointly on decisions over $50,000. Under $50,000, I'm happy for them to act separately. They'll be responsible. So you can break the powers up as well between people, and you can have up to 4 at any time, either acting jointly or separately. So lots of options, lots of flexibility in drawing up these documents. The other thing you can do is put conditions in it, which is what I alluded to. So that then comes back to the duties and obligations a little bit, which I'm going to talk about on the next slide. But some of the conditions that I build in as standard into power of attorney include the obligation that if they are acting separately, that the attorneys should consult each other at the very least. I build in things like if you have a dependent, the attorney is authorized to maintain the dependent. And I build in clauses that the attorney can deal with your bank accounts, your superannuation, your real estate, your mortgages. So all these things I make nice and clear in the document. So that's a lot of information. The types, when they begin, how you can appoint people, what powers you can give them, lots of flexibility in there. So let's take a step back and actually think about what the law actually says in relation to what an attorney, how they should act. So because you are vulnerable in this situation, you have lost capacity, the attorney that you appoint is in a very special situation. They've got lots of obligations to you. They've got an obligation to do what's in your best interest. They can't act in conflict with your interest. They can't act in their own interest. They have to be very careful about how they deal with your finances. They cannot mix your finances with theirs. They have to keep accounting records of what they do because they're dealing with your money, not their own. And so they've got the obligation to make that very clear to anyone who might ask what has gone on. So I generally tell attorneys, don't deal in cash if you can help it, because cash is really hard to account for. Deal directly in an account. Yes, you can transfer via internet banking, but try not to transfer between accounts without an explanation. Try to use an EFTPOS or ATM card. If you have to deal with cash, you have to keep complete receipts, keep a diary, keep a spreadsheet or a book, a running book of what your expenses are that you're paying for. An attorney cannot be financially compensated unless there is an express power to do so, because that is a conflict of interest. They can be reimbursed for expenses they pay for directly, but they cannot take anything for themselves. They cannot make gifts to themselves. Now, this is also a conflict of interest. And this is one of the reasons why I also say that a power of attorney should not begin immediately. I had a man get in a lot of trouble because of this. He didn't understand how the power of attorney worked. His mum had appointed him as the power of attorney. His mum was fine. The power of attorney had already begun because it said it started immediately. There were 4 other brothers and sisters who were estranged from mum and from him. So, of course, this family was already fraught to have problems. She gave him $25,000 to build a pool. She was regularly giving money to help his kids. She generally appreciated him and contributed to his household. Now, she's mentally sound, but the power of attorney has begun. He's not actually taking the money himself, but he is receiving gifts that she's giving. Problem is, she then lost capacity, went into a nursing home. He couldn't prove that she made those gifts. He was accused of giving money to himself as attorney, which is highly illegal. He had to pay all that money back. So there were multiple problems there. The power of attorney began immediately, which is why I think that that's a big issue as well. Second problem, he didn't understand that he couldn't receive gifts, that there was the potential that this whole problem would happen. And also, neither did mum. If mum actually recorded that she was giving the gifts herself, then there would have been evidence and the family could have done nothing about it. But it was just a horrendous situation. So they have to act in your best interest. They can't act in conflict with your interest. They cannot act in their own interest. Now, another fine line that could be crossed is if you appoint your spouse as the attorney, your interests are generally aligned. So when are you acting in your own interest or their interest? If your interests stay aligned, then that's fine. If your interests start diverting, you've got a problem. The other thing is that as a spouse, you might be taking money for yourself, which you're not allowed to do as an attorney. So that is why in the powers of attorney I prepare, it specifically says that there is the power to maintain dependence. Because particularly if there's children as well, particularly young children, so if it's because there's been a car accident or some other horrible scenario, the attorney is supposed to act only in the best interests of the person that appointed them. But there's also children. And so we can't just forget that those children also need to be maintained. If gifts are a thing that needs to happen, then a power can also be built in as well. It needs to expressly say that the attorney is allowed to give gifts. You can say up to a certain amount, you can say to whom, so that it can't be questioned. You know, if you appoint one of your children and you want to make sure that your grandchildren, so their children, are still getting presents regularly, then it's safer to build it into the power of attorney so that your child is not accused of taking your money to give to their children. Now, all of these horrible scenarios really arise when there's an issue in the family. When there's no issues in the family, things can go very smoothly. However, we also have a lot of elder abuse. We know that this does happen. Powers of attorney can sometimes be a tool to enable elder abuse. So when solicitors draft them, keeping this in mind is important. And again, that's why I don't like them to begin immediately. Because why give your power away and then start having someone walk all over you even earlier than necessary? If you've lost capacity, you're more likely to then be in a facility where there are independent people who are going to be checking on what's happening. If you are mentally well, but for example, living with one of your kids and you've given them a power of attorney and they start having some financial power over you, and start dipping into your account whenever they want to, is just fraught with danger. Now, the reason why financial elder abuse can go on is because if there's no one to pull up the attorney, then it can continue. So there's no police over this scenario. If someone notices something, they could report it to the police, but the police is most often going to say, well, it's a family issue. So what do you do when something is going wrong? I was involved in a similar scenario a few years back, where an elderly woman appointed her 2 daughters. This woman had lost capacity. The daughter who contacted me was interstate and she'd really not used the power of attorney at all and left it up to the local daughter who lived near mum's hospital. Unfortunately, it had come clear that the daughter who lived close to mum had not been abiding by her obligations had been crossing that line and abusing her mother financially, had been using the power of attorney, which she had given to the bank, to go regularly to the bank and take money for herself, to the point that there had been hundreds of thousands of dollars taken by this daughter. The mother was destitute, in care with dementia, and this daughter had gambled it all away. So the other daughter who contacted me went to police. Yes, there were some proceedings taken. Ultimately, so what? I also helped her go to VCAT, have the power of attorney overturned, removed the other sister. So the sister I was acting for ended up being the only person able to help her mum. But the damage was already done. Even though there was a recovery order for the money that had been stolen, she'd gambled it all away. They weren't going to ever get it back. So too late. And it is tragic when you see it. So a couple of things, I suppose, around that scenario. If the sisters had been appointed jointly, then the gambling sister wouldn't have been able to act alone. She wouldn't have been able to be withdrawing money without the authority of her other sister. That power of attorney had also begun immediately, even though by the time we discovered the problem, mum had dementia and was in a home, it had actually been happening for a long time before mum had lost capacity too. So those are some, and I suppose a couple of stories that you've heard tonight around some of the specific things that you need to think about when doing a power of attorney, or if you're appointed as someone's power of attorney, to check that document, because so many solicitors do a really poor pro forma power of attorney, where they don't put in specific powers, where they have it begin immediately, when they don't divide powers out between people, when they don't have people acting jointly. So enduring powers of attorney are a great tool and really necessary, because they fill that gap between when you lose capacity and when you die, because you don't want your family scrambling to try and keep things going in that emergency situation. But at the same time, we need these practicalities and protections to be balanced. So coming back again to what is involved in estate planning these days. So I did cover off on that briefly. This little poker chip image is something that I use in terms of explaining what is included in the family legacy plan that me and my firm do for people. When people come to do their estate planning, this is what you get in the family legacy plan. So we look in detail at how property is owned. We do wills, we do the enduring powers of attorney, we do the appointment of a medical treatment decision maker, we do look at advanced healthcare directives. Superannuation is not covered by your will. We make sure that that we do what is needed to make sure that it gets where it needs to go. We consider whether we need trusts in the will. We look at life insurance to make sure that it is going where you want it to go as well. If there are young children, we make sure that proper instructions are done for the guardians of those children. If there are family trusts, if some assets are held in an investment trust or a business is run in an investment trust, we have to make sure that the powers go to the right person, the control transfers, because assets owned in a trust are not covered by a will. And the last 2 points are that I don't like a list of personal effects in a will of gifts. I like that in a separate document. So we we go through that process. And the same thing with memorial instructions and instructions around your funeral. People don't usually look at your will until after a funeral. So you need other plans to make sure that your wishes are carried out in that respect. So it's comprehensive. It really is. And the process is not overly complicated, even though it looks like a lot. It takes 2 appointments over 2 weeks. We guide you through it. In the initial appointment, we get all the information we need from you just through the guidance of our questions. You don't need to prepare all that much. We do send you some initial information beforehand to get you thinking. It doesn't really matter to us whether you get that back to us or not before the first appointment. Between the 2 appointments, if there's information we don't have from you at the first appointment, we get that from you. For example, if there's some things we need to look at from the accountant, or if there's full names and addresses that you haven't got to us, we draft the documents for you. We get those to you before the second appointment. So at the second appointment, we've already finalized drafts. We sign everything at the second appointment, and then you've got valid documents done at that second appointment. The delivery of the final documents is that with powers of attorney, the people you appoint have to sign acceptances as well. So we go around, we make sure all the acceptances are signed, then we deliver you certified documents. With the COVID emergency regulations that we have at the moment, we are able to do this all remotely via Zoom. We're allowed to witness and sign things electronically at the moment. So we use the same process, we're just doing it on a screen. So with all of that, I would hope that you'd have peace of mind. Everything is in order. We make sure that it's nice and clear. We make it as watertight as we can, so there's little chance that there will be conflict. And we make sure your assets are protected in the way you need them protected. People often ask, well, what's the cost? In Melbourne, you'd be looking at paying at least $3,000 for this kind of thing. I don't have to pay Collins Street rent. So a couple gets all of that for $1,100, not each, that is total. So we've gone just over the half hour, and hopefully I didn't talk too fast for you, because I tend to do that when I get into it. But thank you for hanging in there. My email is on the screen. You are welcome to email me and ask me anything you like. I will respond within reason, and usually within 24 hours. Yeah, so let's have a look at some of your questions to see how we've gone in terms of powers of attorney. All right, remember there's a chat box, there is a Q&A box. I prefer the chat box. Q&A is empty, so wow, I must have done pretty well. I am going to end the recording in just a second. And for those of you who attended live, we're going to have a little bit of a chat about anything you want me to ask me in a second. But again, for those watching the replay, you can either email me on the email on the screen. That's my direct email. I'll get back to you, like I said, within 24 hours. Or there is a question submission there as well.